morning, everyone. I hope you're keeping well and hopefully enjoying a bit of respite after the mad rush at the end of last month. Thank you for taking the time to join us today, where we will be revisiting our most popular webinar of 2020, Tips and Traps in Residential Conveyancing. My name is Stephen Smith, and as always, I'm delighted to be joined by Ian Quayle and my colleague, Robert Kelly. Good morning to you both.
Good morning.
Ian, I think it's fair to say a lot has changed in the last 12 months in the world, so this should be a very interesting session.
Yeah, it's amazing that despite everyone being so busy with actual what I would class as combat conveyancing, lots of things have happened that I want to sort of talk about today, and sort of a change in attitude with regard to claims and people being concerned about claims. So one of the things I think is, given that everyone's been so busy, given that everyone's been working from home, given that we've had to have a sort of more relaxed attitude with regard to being unable to contact clients directly and see them face to face, there are some sort of significant issues that we can talk about today, sort of really flowing on from what we said, what was so 12 months ago now. Quite amazing. Yeah, so lots to talk about.
Yeah. Absolutely, yeah, incredible, but it has been 12 months in a way. It doesn't feel like 5 minutes ago. Ian, before I hand over to you, I'd just like to go through a few items so everyone knows how to participate in today's event. You're listening by default through your computer system. If you would like to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. You will have the opportunity during today's session to submit text questions to Ian by typing your questions in the questions pane of the control panel. You can send your questions in at any time during the presentation, but we will collect these and address them during a Q&A at the end of today's presentation. You can also raise your hand during the presentation if you're having any difficulties with the sound or any other technical issues. I'm no IT whiz myself, but hopefully we can speak to you over the chat feature and resolve any issues. Finally, before I hand over, we've included the notes for today's section in the handout section of your control panel. There should be a tab that says handout if you're looking for the notes. And we've also included some links to our YouTube channel and our LinkedIn page. Our LinkedIn page has details of the webinars we run and news of our new products. And on YouTube, you can find recordings of previous webinar sessions, as well as walkthrough guides for our online ordering portal. Anyway, that's enough from me. So I'll now pass over to Ian for the main part of today's presentation. Thanks, Ian.
Thank you, Stephen, and thank you everyone for coming along today. It's very kind of you. And before I sort of start my presentation, just a massive thanks to Stewart over the last year. I remember when sort of lockdown occurred, and I don't want to sort of hark back to those horrible times, but it was amazing how Stewart sort of came up with the idea of doing these webinars, offering them free to the legal profession, and being really supportive of the legal profession throughout the sort of bad times. And I'm delighted when speaking to Stephen and Robert, the amount of feedback and indeed the amount of work that Stewart has derived from these presentations. So a big thank you to everyone that's been supportive of myself and Stewart over the last year or so. And it's nice to see some glimmers of light, isn't it? I'm not entirely confident that the good times are immediately around the corner, but it's nice to see things getting back to a form of sort of normality, despite some problems. And again, as far as business is concerned, Stephen's right. Yeah, the SDLT window is closed, and to an extent, there's a bit of a respite. But speaking to people the last sort of week or so, they're busy, and long may it continue. Hopefully, not quite as busy, not quite as manic as it has been. So, what I want to do today is really just revisit the presentation that I did 12 months ago, and just highlight some issues and highlight what's happened and what changes have been made since then. And the most important thing I think that we need to explore and be aware of is what insurers are telling me. I had this horrible feeling, and I've had it throughout the pandemic, that we've got an absolute brilliant opportunity for fraudsters to perpetrate fraud, given some of the points that I made a little earlier, and given the fact that, well, what else could fraudsters do in lockdown other than think about weird and wonderful ways of defrauding whoever they can? And I think conveyancing, residential conveyancing in particular, is still a sort of a honeypot for fraudsters, and we've got to be aware of that. And in addition to that, working from home, working with our colleagues, and despite the support that most firms have provided to fee earners, we haven't had the opportunity of being able to say to a colleague by knocking on the door and sitting down in front of them for 20 minutes, hey, what would you do with this, or what would you do with that? So working from home, I think, has caused problems as well. So what insurers are saying to me is that there's been a sort of radical shift over the last few years with regard to claims, going from sort of mistakes made procedurally with regard to mistakes or problems arising with regard to the sort of client-lawyer interface. And therefore, that's really what I'm going to be focusing in on today and the sort of main theme of my presentation: how we effectively communicate with clients, how we transmit the information that is vital to them. And in essence, we'll be going over, to an extent, some old ground, but we'll be putting a different emphasis on things and also just looking at what we do and how we do it with regard to clients. So hopefully you're all sitting comfortably, and hopefully you can all hear me and see the slides, which is most important. I'm going to turn off my camera for a moment or two, just to make sure that we improve connectivity. And hopefully, as I say, you should be able to see the slides and continue to hear me. The first point I want to examine today are issues with regard to boundaries and boundary sensitivity. Because the question that I pose on the slide, how do we find the legal boundary? The answer is with difficulty. The second question, does it really matter? Well, in most residential transactions, it doesn't matter that much. But boundary sensitivity with regard to transactions is a common problem. And what I want you to be aware of is that we should be extracting from clients circumstances where there is boundary sensitivity. There's a number of ways that we can extract that information, as we'll see as we progress during the course of the next hour or so. As far as advising clients are concerned, I think what we've got to do is we've got to be realistic, and we've got to tell clients about the problems associated with the ascertaining of a legal boundary, and advise clients about the limitations of the conveyancing process with regard to legal boundary identification. It's no good me sitting here and talking to you and creating a problem without generating a solution. And therefore, what I've got are some ideas which hopefully will assist you with regard to providing a solution where we have boundary sensitivity. So the first point to make really is, in most transactions, we've just got to highlight the limitations with regard to the conveyancing process and identifying legal boundary. Where we have a boundary sensitivity problem, we've got to explain to the client the steps that can be taken to try and alleviate that problem. Again, the important point that I would emphasize there is where we're having to do additional work with regard to boundary sensitivity issues, don't forget to charge for the work that you do, or at the very least, tell the client about the additional work that you're undertaking. Let's have a look at a problem. So you're acting on behalf of a client who's buying the area of land just beneath the sort of green, blue, purple line. Sorry, just beyond that line. So there's a property sitting there. You're acting for a client that's buying that property. And the title plan to that property reveals that the boundary to that property at that gate is in essence a broad spectrum that could be anything up to ½ a metre wide. So there could be a problem with regard to boundary identification relating to access. This is a private right of way. There may be an issue with regard to the title plan that means that we are unable to identify whether or not the property that's being acquired abuts the right of way over which the easement runs. Remember, land registry title plans are not accurate. Remember, section 60 of the Land Registration Act 2002 states that a title plan reveals a general boundary, not a legal boundary. Therefore, it's imperative that when we look at that boundary, we ascertain that the property appears to abut the right of way over which the easement runs. If there's an issue, I might do a sim search of the area to check if there's any unregistered land in the vicinity, if the servient land, the right of way, is registered, and if other land in the vicinity is registered as well. But I am concerned that I can identify that my client can access the property being acquired courtesy of the right of way. The next issue is the neighbouring property. If you'll see to the left, as we look at the photograph there, there's a yellow band. That is an indicator of where their boundary finishes and where the right of way begins. Now, the neighbour is concerned about that because he's concerned about repair and maintenance issues. If you look to the left of that yellow line and to the right of that yellow line, you can see the right of way is quite heavily pitted. That's due to some fairly heavy traffic going to and from a neighbouring property. So again, as far as the neighbour is concerned, they're interested in where their boundary sits on the basis that they need to know who's responsible for what. with regard to the repair of the right of way. Again, a title plan isn't going to really assist us, and a title plan is probably going to generate more questions and answers. And if we look to the right of the photograph, you'll see a red line. Let's assume that our client who's buying the property beyond the gate is also buying the area of grassland to the right of the right of way, and is buying that on the basis that it has the potential to be a building plot. Well, again, if that's the case, we need to accurately know where the legal boundary sits between that plot and the right of way, for the reasons that I mentioned earlier. So it isn't necessarily a question of there's a boundary dispute, or there's an inability to identify where the boundary sits. In all of these issues that we've raised, what we're saying is we just need to know precisely where our boundary is to enable us to properly advise our clients. And the starting point really is we can't identify a legal boundary unless we've got evidence of what was intended when these boundaries were created. Invariably, we're looking at unregistered deeds and documents, and they have to reveal what was intended when the boundary was created, and that revelation must be sufficient to enable us to accurately identify the extent of the land concerned today. Well, I can tell you that as far as this track is concerned, going back in the 1930s, the track was widened. Originally, it was a track for horse-drawn vehicles. 1920s and 1930s, it was expanded, it was widened for agricultural vehicles and forestry vehicles. And therefore, there's an issue with regard to the neighbouring properties, the yellow line and the red line, as to just what the width of the right-of-way would be and what is or isn't included in the neighbour's title. As far as the registration process is concerned, land registration itself of unregistered land throws up more issues than resolving problems with regard to boundary identification. Frequently, the land registry, when mapping and registering on first registration, inaccurately record or inaccurately map the registered title. More recently, the land registry is far more accurate than it was historically, but if we're saying that the land behind the gate was registered in the 1980s, it might be that the quality of the title plan and the quality of the mapping undertaken by the land registry is not as good as it would be today. So, do boundaries matter? Yes, they matter for access. Yes, they matter with regard to disputes or potential disputes. And they also matter with regard to client objective. I'm buying this property, I want to extend it. I want to know precisely where my northern boundary is or where my southern boundary sits, so I can build an extension, so I can build a summer house or a garden office as close as I possibly can to a neighbouring property. I'm buying this site on the basis that I think I might be able to build a property in the garden, a bungalow in the garden, and therefore I want to sort of maximise the potential development potential of the site. All of these issues can immediately impact on boundary. So all of these things, I think, require careful consideration. And as I say, it's no good me just creating a problem for you. What I've got to do is try and generate a solution for you. So what solutions do I think are out there? Well, we've already said title plans can't be relied upon. I've already said identifying a legal boundary is going to be difficult and sometimes impossible because, again, I repeat, we're looking at what was intended when the boundary was initially created. I think all we can do is provide clients with as much information as possible with regard to boundaries. In the good old days or the bad old days, I would say have a look at a land registry public guide, provide the client with a copy of that public guide that sets out issues associated with plans and boundaries. Land registry public guides are no longer available, but there is information on the government website that can assist clients and assist you in setting realistic expectations. The next point, and I think this is derived from a lot of case law, to be honest with you, get away from relying or indicating to clients that they should rely on plans and focus in on how properties are described within contract, within estate agents' particulars, within property register. There may be indicators in that documentation as to where the boundary or legal boundary is. I'm particularly optimistic and hopeful that we've got unregistered deeds and documents that might assist us. So providing clients with as much information as possible, I think, involves two things. One, saying to the client, hey, we've got a difficult job here, and most of the documentation I'm going to be providing for you is not going to give you a fix as to location of boundary. And secondly, explaining clients that we've got some information that might assist the client. So let's go back to our diagram and our photograph for a moment. Okay, let's assume we're acting for a client who's buying the land beyond the gate, the property beyond the gate. I would provide that client with a copy of the agent's particulars. I'll provide the client with a copy of the title plan with a warning that they can't safely rely upon it and that it is an indicator as to the location of a general boundary, not a legal boundary. I would provide the client with any other plans, any other documentation that I've got or the seller has provided. I'd also provide the client with a copy of the survey or valuation if it's in my hands, and say to the client, look, I want you to inspect the target property and tell me that all the documentation that I've given you, including the description of the property, is consistent with what you see. And if it isn't, let me know. And if the documentation is inconsistent as between other documents, then again, let me know and I can investigate further. So I think that's the first thing that we do. We are dependent on client inspection, and we're also dependent on surveys and other sources of information relating to the property. And really what I'm asking the client to do is to say, when he inspects, when he looks at documentation, everything that I've given him, everything that he or she has seen is consistent with what I'm saying is what he's buying or what he or she thinks is being bought. So I think that's critical, okay? As far as that information is concerned, if the client comes back and says there's a problem, if there is a boundary dispute, if boundary sensitivity is a real issue, what can we do? Well, first of all, as I mentioned, legal title boundaries are invisible, and in essence are a pencil line between my title and your title, assuming we're neighbours. So the moment we start looking at any plans, we've got a problem. We've got to look at what was intended when the boundary was created, and significantly, we can look at the deed or document that created the boundary and any of the documents that were available at the time to the parties to assist us with regard to identifying intent. Are there references to physical features in a document that is our source document? There are general boundary rules and lots of legal presumptions, but the important point is they are presumptions that are capable of being rebutted. So just over the weekend, someone sent me an email about a problem with regard to where a property ends and a highway begins. And the argument was, well, the highway appears to be between two hedges, and the general presumption is where there are two hedges between a highway, then the highway is the extent of the land between the two. And that's correct. But the presumption only applies if the hedges were planted at the point that the highway was created. If you can prove that the hedges were created at a later date, the presumption doesn't apply. And I mentioned the case of Pennock and Hodgson, a 2010 case, where the Court of Appeal sent some very heavy warnings to practitioners about issues associated with boundary identification. Be careful about relying on legal presumptions. Be careful about relying on documents. Place great emphasis on the wording, the description of properties, particularly in old conveyances, and look out for physical features or references to physical features when trying to identify boundaries. Setting realistic client expectation, I think, is the key with regard to this problem. For new boundaries, use national grid coordinates or refer to physical features and measurements and make sure plans are accurate. Great tip, be aware of the boundary dispute protocol. There is a website called Property Protocols. That protocol is very useful. The boundary dispute protocol is very useful, as we'll see in a moment or two. Have a think about making sure that we agree with our neighbour or intended neighbour or future neighbour as to where the boundary will be, and enter into a formal boundary agreement or make a determined boundary application to the land registry. These are our magic fixes for the problem that I've just identified. The boundary dispute protocol emphasises a number of points when dealing with registered land. Check the register, not the title plan. Look for unregistered deeds and documents. I always say to practitioners that the land registration process is in essence a veneer, a very good veneer, a very high quality veneer, a veneer with a guarantee, But where we're encountering problems, where boundary sensitivity is an issue and my client is screaming that he needs to know precisely where his legal boundary is, then I think to an extent land registration doesn't help us, subject to the issue of making a determined boundary application, which we'll talk about in a second or two. I mentioned sources of information, statutory declarations, photographs, tenancy agreements, etc. Watch where the boundary problem arises due to adverse possession, because in those circumstances we might as well put all the documentation we've got assisting us with what was intended when the original boundary was created in the bin, because really what we're looking at are statements of truth, statutory declarations, etc., from the potential adverse possessor with regard to what they're saying. I mentioned be careful when instructing chartered land surveyors. Why? Well, chartered land surveyors are expensive. They tend to be very good with regard to the evidence that they produce and reports that they produce, but they're only as good as the evidence or information that's given to them. And it's imperative that if you are instructing a chartered land surveyor, they have the evidence from your side of the fence, if you pardon the pun, and the side of the fence from the neighbour. And it's also important to understand, are they advising you and your client with regard to the preliminary problem, or are they going to be utilised at some point in mediation or litigation? If that's the case, instructing them to assist you in the first place is going to probably prevent them from giving expert evidence at trial or in mediation at a later date. And again, I've seen it on a number of occasions where a chartered land surveyor has been instructed at great expense at the beginning of the problem, then found out that it's necessary for another land surveyor to be instructed in order to give evidence at court or in mediation. As far as boundary agreements are concerned, some good points. Don't have to comply with Section 2, subsection 1 of the 89 Act, unless the agreement involves a transfer of land. Agreement doesn't need to be in writing, but common sense suggests it should. The land registry should give them guidance as to wording that's used and, significantly, is prepared to note an agreement on the relevant registered titles. So if you've got a friendly neighbour, or you're able to reach an accommodation with regard to location of boundary with neighbour, then a boundary agreement is useful. Determined boundary applications are also useful, but important point. They may resolve boundary disputes, but they're not a vehicle for doing so. They do stop the clock ticking in connection with adverse possession claims arising due to boundary encroachment. Where we've got neighbours that agree the location of an indistinct boundary, or where there's been a boundary problem or a boundary sensitivity issue, and we've got a cooperative neighbour, brilliant. Brilliant means of resolving the problem. Where there is a dispute, then we've got to be careful. And the reason that we've got to be careful is the land registry will not internally determine a boundary where there's a dispute. They'll refer the matter to tribunal, and a tribunal won't fix a determined boundary where there's a dispute. A determined boundary application that goes to tribunal is only going to be of merit from the applicant's perspective if they're submitting a plan that is an appropriate plan for a determined boundary file plan, so it must be professionally prepared, and there is agreement as to where that boundary sits. The land registry has confirmed that the tribunal has a binary jurisdiction. Is the plan accurate? Is there agreement? Yes, the land registry will be told by tribunal to determine the boundary. If there isn't a plan that's properly prepared, and if the neighbours are not in agreement, then the land registry won't. I've given you some case law, a case called Wick in the notes, where, quite interestingly, the judge who dealt with the matter had in the past been prepared to sort of come off the fence, again, pardon the pun, and resolve a boundary dispute. But in this particular case, was saying, well, no, I don't really have an entitlement to do that. Again, highlighting this binary role with regard to first-tier tribunals. Chartered land surveyors, I've made the point. Be careful. Make sure you've got a chartered land surveyor who does this sort of work, is given as much information as is possible from both claimant and potential defendant, and you and they understand what their role is. Are they giving guidance to you or the other side, or are they going to be instructed in order to give evidence at trial or mediation? And that leads me to an important point. The courts don't like boundary issues, they don't like boundary disputes, they don't like neighbour disputes, to be honest with you. and therefore it's imperative before you embark on any form of litigation or advise a client to do so that you've tried mediation beforehand. Other evidence, I've mentioned extrinsic evidence, evidence which is probative of what the original parties who created the boundary intended when the boundary was created. Plans, photographs, documents, oral evidence, all usable, as long as we can relate it to the time when the boundary was created. So that is a brief scamper through some issues with regard to boundaries. And as I say, looking at it from a claims perspective, what insurers are telling me is that it's the way that we're advising clients that's causing problems and will cause problems in the future, and therefore do be careful. The next thing I want to talk about is co-ownership, and co-ownership causes claims and it causes complaints from clients. And it causes claims and it causes complaints for two simple points. One, we make assumptions. Two, we don't have sufficient information on our file in order to give appropriate advice. So it is absolutely essential when dealing with co-ownership that we have evidence of what the clients intend with regard to contribution and also with regard to their intended beneficial interest. So we need to know about financial contributions, initial contributions. I also think we should know about clients' intentions medium to long term. So, hey, I'm likely to get a bonus at work. I'm going to plow that bonus into a new extension on the property that we're buying. Or I've got an elderly relative that's going to come and live with us, and we're going to build an annex or something to the property that we're acquiring. These sorts of things may have an impact on co-ownership or how the beneficial interest is held or how the beneficial interest is identified at a later date. But it's important that clients understand that those changes, those circumstances, medium to long term, would require the issue of co-ownership and the beneficial interest being readdressing, if there is such a word. So the important thing I want to emphasize here is I think we should be using co-ownership questionnaires, and we should be making sure that clients complete the questionnaires, confirming how much contribution they're making, what future contributions will be, how the mortgage is going to be paid, and what the client's wishes are with regard to the beneficial interest. I think it's important that we have client questionnaires that are completed. If you don't have a questionnaire, if you want to see one, drop me a note and I can send you a copy of one prepared by a barrister called Alan Tunkel a number of years ago. That's very useful, so that you've got evidence on file as to what your instructions are. With regard to the danger of making assumptions, what you've got to do is offer clients choice. And the choice is, well, we own the property in the sole name of one of you, we own it as joint tenants, we own it as tenants in common in equal shares or unequal shares, depending on contribution. We then provide, if we've got all this information from clients, guidance or advice given the circumstances that we're told about. But at the end of the day, it's the client's choice. I mentioned this case of Turner and BROMETS Jackson in the notes. Quite an interesting case because in essence what you've got is something that's not uncommon. Dissatisfied former partner getting very short measure with regard to the sale of a property and then arguing, well, hang on a minute, I wasn't aware of the vulnerability that I had given how the beneficial interest was held courtesy of deed of trust. So this was a situation where client says, my conveyancing lawyer failed to advise me of the legal obligations and duties that I owed generally in connection with the declaration of trust and didn't explain to me that there was, in receiving an equal contribution, a smaller contribution than my partner, I was being put at a disadvantage. The underlying theme from the claimant here was that whenever a party is advised to or suggests or instructs lawyers that there's an unequal contribution and an unequal distribution of beneficial interest arising, there's automatically a conflict of interest. And the court wouldn't have it. Luckily, the lawyers involved got their act together. They had provided the client with a questionnaire. So the clients were giving the firm information about contributions, about what they wanted with regard to beneficial interest. The lawyers had carefully explained what the declaration of trust was doing. And there was clear evidence on file that the claimant was aware of her position. So the judge had an awful lot to lean on with regard to protecting the defendant firm. The thing that I see from time to time is a situation where there is a brief file note on a conveyancer's file, discussed co-ownership. Client wants joint tenancy or tenant in common on an 80-20 split. And there may be an email or a letter to the client going out beforehand explaining the various choices, but that's about all. I think we've got to be careful about being protective of ourselves with regard to this sort of claim, making sure that we have evidence that the parties are aware of their position, aware of the disadvantage that they're putting themselves in, where they're agreeing that the beneficial interest is held so that their beneficial interest is significantly less than the other party, so that we've got ammunition to defeat claims and ammunition to deal with complaints. Because you can understand, can't you, how where someone, particularly where property prices are rising phenomenally, there's a great deal of equity in a property, feeling aggrieved. Well, he or she's getting 80% of the net proceeds of sale, and I'm only getting 20. The 80% is going to be enough for that person to be rehoused very comfortably. The 20% that I'm getting is going to provide me with a deposit on something significantly smaller than I'm used to or expected or have expected. So I think we've got to be careful about that. The other case, OXLEY and HISCOCK, again, making sure we're inquiring about sources of funds, inquiring about responsibility for paying the mortgage, extracting information from the client so that we can give proper advice. And as I say, don't assume anything. I and my partner instruct you to act for us in connection with the purchase of a property. The current property that we own as joint tenants. Therefore, you may think, well, they own an existing property as joint tenants, they're in a stable relationship, they're making an equal contribution in connection with the new purchase, it should be held as joint tenants. Well, is that necessarily the case? Is that what we actually want? Again, I'll be making inquiries about, well, have you been in previous relationships? Do you have children from previous relationships? It's all well and good looking at what actual contributions are going to be, but what's your objective? What's your plan with regard to this property? And again, just making sure that clients are advised as to the fact that they need to keep how the beneficial interest is held under review. We need to explain, in layman's terms, the implications of a joint tenancy, what happens with regard to survivorship, what happens on death of both parties, and what happens if only one party wants to sell, and explain the implications of a tenancy in common and the death of a tenant in common. What happens again if one of the tenants in common intends to sell? The relationship has broken down. Some scary stuff here to talk about. We've got to tell clients where they are buying as joint tenants that the joint tenancy can be severed. And I can also refer you to case law that says you should be explaining the mechanics of severance. And in particular, that a severance of a joint tenancy can be a unilateral decision on the part of one of the joint tenants. There's nothing that the other can do about it. So explain the client's choice. Make sure that we've got documentation to support what we've been told, what our advice is, what the choices are. Think about what happens if the parties fall out, and think about what happens in the future, where our clients are holding as tenants in common and there's a deed of trust. The deed of trust needs to be kept under review. Where our clients are buying as joint tenants, they need to be aware that the joint tenancy can be severed, the implications of severance, the creation of a tenancy in common in equal shares, and the mechanics of severance. With regard to the mechanics of severance, clients need to be aware of the process, the use of Form SEV, the use of Form RX1, and land registry requirements for supporting documentation. I'd be saying to a client, if you want to sever the joint tenancy, you've got to instruct either us or someone from our family or private client department to give you advice as to the mechanics of severance. But as a transactional property lawyer, as a conveyancer, my clients need to be aware that a joint tenancy can be severed, how it's severed, and the significance of severance. The reason I mention that are these two cases, Singler and Brown and Boycott and Williams. What can we extract from case law? Well, Boycott and Williams in particular, lawyers potentially negligent in failing to advise a client in connection with the joint tenancy of the fact that his joint tenant could sever the tenancy and create a tenancy in common, and that there was nothing that the joint tenant could do about that wish to sever. What can we extract from case law? The need to ensure that we don't just think about transactional issues, but also the future. That clients can have an explanation so that they understand and appreciate the significance of co-ownership in connection with the acquisition and going forward. The next thing I want to talk about are some issues with regard to due diligence. And again, I'm highlighting here the fact that what insurers are saying to me, what professional indemnity insurers are saying to me, is that we've got to be careful about getting messages across to clients. And we've also got to be careful about not proceduralizing, there's another funny word for you on a Wednesday morning, not proceduralizing and making the process too administrative, but thinking about client objective, thinking about the practicalities and individualism of the transaction. In other words, there's no such thing as usual searches. There's no such thing as standard TA forms in a transaction. Yes, the protocol requires it, but there may be additional inquiries that we should be generating given our client's objective, given the transaction, given the property. As far as searches are concerned, I think what we should be doing is saying to clients, these are the searches that are available for the property that you're acquiring. There are certain searches that are essential. There are certain searches that we recommend, but there may be other searches that you'd like us to do. I think we've also got to look at our client and determine what sort of client we're acting for. Are you risk averse? Are you nervous about the transaction? Are you an inexperienced first-time buyer? Are you elderly and unaware of some of the issues associated with some of the search results that we will be receiving in connection with this transaction, as opposed to searches that you've seen in the past with regard to other transactions? I think that's important. I think it's also important to explain to clients the limitations relating to searches, and to explain to clients that where we're getting adverse entries with regard to search results, what steps should be taken by us to protect our client. And this is a big thing, but one professional indemnity insurer in particular has been highlighted. You can't just send me a local search and say there's a smoke control order, there's a tree preservation order in place, there's an issue with regard to a planning condition. You've got to tell me what additional steps can be undertaken in order to clarify the extent of the problem that the search result is generating. And I think that's the thing I want to get over this morning. The fact that we're not just a mechanical exercise. There you are, Mr. Client, there's the search results. Have a look at it and highlight adverse entries and leave it at that. You've got to say to the client, these are the things that we can do to assist you to clarify the position, to identify the extent of risk, to identify how that impacts on client objective. And there's another point that flows from that, which again is quite interesting. And again, this was another professional indemnity insurer saying, we've got to understand and appreciate that the conveyancing process is not a series of individual steps, that there is, in essence, a combination with regard to client inspection, search result, due diligence with regard to title. So our client wants to use the property that they're buying as a home office. Well, all right, in those circumstances, is there an office in the garden? Is there a building that can be converted to an office? Does it have the appropriate systems to enable it to be used as an office? The appropriate services to be used for an office? Are there restrictive covenants that impact on the use of the premises as a home office? Are there any planning conditions that impact? So in other words, what we're doing is not reporting to the client about the local search, local land charges search and additional inquiries of local authority, and reporting to our client what the official copies of the register reveal. We're lumping them together and saying your objective is in part that you're going to use the property you're acquiring as a home office. These are the issues that we've identified. We're just reading in the States Gazette over the weekend, not the latest one, but an earlier one, about problems with regard to Airbnb and I've done a webinar on Airbnb issues on the basis that if you're owning a leasehold flat in central London, there'll be a raft of covenants that are potentially going to prevent you from using your flat or apartment for Airbnb purposes. We need to think about pulling advice together so that we are looking collectively at client objective, so that we're looking at the issue, the transaction, from the perspective of a risk-averse client or a nervous client or a first-time buyer. When I talk about avoiding claims and problems, in essence, what I always say to practitioners, we've got to focus in on just doing the simple things well, making sure that we're effectively communicating with clients. So again, last week, looking at a firm's systems and procedures and looking at their reports on title to clients. And I have to say, beautifully drafted, very carefully considered precedent form of report on title to a client, but running to 60 pages of fairly intense information. And you look at it from the perspective of an elderly client, first-time buyer client, and an experienced client, and the whole mass of information must be daunting. And if I was a betting man, which I'm not, the likelihood of the client digesting all of that information slim. I do think that we have to produce a report on title to our clients, but I do think we have to make sure it is produced in such a form that the client can read it, digest it, and understand it. And I think to an extent that it breaks my heart to say this, we've got to move away from what I would class as a defensive report on title. There you are, Mr. Client, there's everything, because I'm terrified that you might sue me. I think there is a halfway house, and the halfway house is providing information to the client in a piecemeal way, and then the report on title bringing things together, bringing the threads together, and tying them into client objective, and highlighting to clients who are nervous or sensitive or risk averse what we can do to protect them. I think to avoid problems with regard to searches, we should explain limitations of the searches. We've got to explain if a search reveals the need for further investigation, what further investigation is required. Again, I'm alive to the fact that we should be saying to the client, if they want us to do further investigation, there's a cost implication. And I'm also aware of the fact that as a transactional property lawyer, I'm not a planning expert. I'm not a tree expert. I'm not a highways expert. I'm not an expert with regard to log burners or indeed anything else. But I've just got to flag up to the client, look, given that, and given the limitations with regard to my role, we need someone to have a look at this issue for you to protect you, to give you advice about the status of the wood burner, to make sure that it can burn smokeless fuel, to make sure that it's been installed correctly, to make sure it's been serviced properly, etc., etc. So when I talk about further investigation, I'm not for the life of me saying all of a sudden we've got to become planning experts, Japanese knotweed experts, or indeed anything else. I'm just saying we see it during the transaction, we highlight it, and we say to the client, this is what you can do. Where a client doesn't heed or take our advice, again, record the fact that the client is aware that we've given advice and the client is happy to proceed without it. As far as essential searches are concerned, again, just be aware and make sure clients are aware that searches can be defective. Do be aware of the fact that Stewart Title is able to produce product and indemnity policies where there are delays with regard to local searches, and be aware of the migration of local land charges to the land registry, which hopefully will speed up the process of the production of local land charges searches and make life a lot easier for everyone. That program with regard to migration is a 5-year program, but the land registry has started it, and there is some positivity relating to where local land charge services have been migrated to the land registry. Drainage and water searches, be careful. Environmental searches and reports, I think, are appropriate for any property, rural, urban, freehold, leasehold, old or new. There is a risk to a client who buys a property of being liable for contamination, pre-existing contamination on that site, or contamination that migrates onto it. Again, our clients are aware of fact. I do think we need to be concerned about transaction-specific searches. Think about client objective. Think about, are there searches that will insist in generating information pertinent to that objective? And ask clients, are there any investigations? Are there any searches that you'd like us to investigate or to undertake on your behalf? I've given you Orient Field Holdings and Bird, another case, AW Group against Taylor Walton. Both of these cases confirm, they're commercial cases, commercial property cases, but both confirm that where you've got an adverse entry in a search, your responsibility is not to give advice relating to that entry, but to give advice as to where the client can go to get advice. So these cases aren't scary at all. They're just saying, hey, if there's a problem, you should be telling the client to seek specialist advice. That's all. And the problems, the claims related to the fact that the claimant, the client, was of the view that they hadn't been given that advice. So it's not sort of increasing what a conveyancer should do, or the scope of the retainer from the conveyancer. It's just saying, as part of your retainer, be aware that we've got to do a bit more hand-holding for clients that some practitioners envisage. Of course, we can get indemnity policies to cover delayed searches and no searches. Again, it's important to explain what indemnity insurance does, and again, it's important to explain to clients the benefits of indemnity insurance in circumstances. Again, Robert, I don't know if you're listening, but certainly people can contact you if there are any issues with regard to due diligence and problems associated with title, obviously, but also issues or problems with regard to delayed searches.
Yes, Ian, I mean, we offer those products, and over the past year have created a number of new versions of it to cater for some of the unusual situations we've got. You're right on the point to explain exactly what indemnity insurance does, because it is a financial reward. It's based on diminishing value of the property, and it doesn't cover the emotive reasons why somebody is buying a house, because they like the garden, because it's near to grandparents and so on. So that needs to be explained. And we have in the past, for some clients, prepared a sort of a fact sheet there, just trying to explain that to clients so that it can be passed on to them so they fully understand. It's not a magic panacea, but it does help.
Yes, yeah, that's a good point. You see, so Robert's just emphasised there the fact that, you know, it isn't enough just to say, oh, and take out an indemnity policy, but it's important to explain to the client what that policy does and doesn't do. And as I say, Stewart Title there are kindly able to produce a fact sheet that can assist you. And again, there are other resources that can be utilised. So leasehold transactions, the Leasehold Advisory Service has a raft of information that you can provide to me as a client if I'm buying a flat. First time buyer of a flat, I need to know about the duties and obligations I owe to a landlord and that the landlord owes to me. It's not necessary for you to provide me with a vast report relating to the relationship of landlord and leaseholder, simply to point me in the direction of where I can gain information or to assist me. Well, the same point that Robert makes here. It's not necessary for you to explain the potential problems associated with indemnity insurance and the limitations relating to it, but it is important, I think, to explain to the client what it does and doesn't do. And as I say, a fact sheet from Stewart Title will assist with regard to that explanation. And again, just being realistic with regard to clients. Certainly with regard to indemnity insurance, I've seen clients, and I've spoken to clients over the years, who think it's a magic fix, that's the job done. The problem has gone away. The problem hasn't gone away. In essence, what we've done is provided some form of financial redress, courtesy of the indemnity insurer. TA forms, again, a similar point here. If we're acting for a seller, let's be realistic. One, the seller should answer the replies in the TA forms honestly. There is no need for you as a conveyancer to assist the client with regard to the information in the forms. The client should be completing them of their own volition. Your task is simply to look at what the seller is saying and check it against the information on your file, and to highlight to the client if any of the information the seller has generated is clearly defective. To warn the client about the vulnerability of a misrepresentation claim if lies are told or mistakes are made with regard to the TA forms, and the duty of the client to advise you and to advise the other side if any of the information within the TA forms alters. As far as the conveyancer is concerned, therefore, there's a relatively small, limited brief or role in connection with TA forms. Checking what's said against information in your file, advising seller about potential vulnerability for misrepresentation and the need to advise in the event of changes of circumstances and changes of information. Not possible to limit or exclude liability within the conveyancing protocol, but the conditions of sale 5th edition to an extent do limit liability in any event. From a buyer's perspective, if we're dealing with TA forms, the position is slightly different. I would advise a buyer client that it is potentially possible to sue for misrepresentation if the seller has provided incorrect information within the TA forms, with a caveat. This is going to involve you in litigation. That litigation is likely to be expensive, it's likely to be slow, and there isn't any guarantee that you're going to win. So I always suggest to buyer clients in the residential context that they use the TA forms as a checklist to satisfy themselves as to the questions that have been posed. Again, remember, we can raise additional inquiries. And if we've got transaction-specific, client-specific, or property-specific inquiries that the client wants us to generate, we should generate them. So I'm just doing some work at the moment with regard to an acquisition of residential property. It also includes an off-license. So there's a whole raft of inquiries being raised in connection with a premises license, etc., and other licensing issues. The client doesn't really want to use the shop as an off-license, probably doesn't want to use the shop as a shop, to be honest with you, but nonetheless, given the fact that these premises are an off-license and there is a license in place, additional inquiries being generated. Problem areas, I think we do have to explain the limitations of searches. We have to be careful with regard to adverse entries and explain to clients what steps are available, choices and cost implications. And don't forget lenders. And what I'd be saying to a lender, look, the client is saying he's not bothered about the fact that these premises have a license for the sale of alcohol, but has your valuer or surveyor taken it into account with regard to valuation? And again, if you've got adverse entries, what does a lender think? And what's the lender's view with regard to those adverse entries? And again, important point, something I haven't mentioned, I should have mentioned when talking about co-ownership. There's no such thing as a collective client. So if you're acting for myself and my partner, as I mentioned earlier, it might be that I'm quite happy to proceed, notwithstanding there's a tree preservation order with regard to an oak tree in the rear garden of the property we're acquiring. Might be a major issue for my partner, and therefore it's important that both of us are aware of the problem, of the issue, and how the issue can be resolved. Client inspection is something I touched on when we talked about boundaries, and I said we'd get back to it, and so we better had to. Clients should be inspecting before exchange to identify state and condition of the property, to identify physical extent, accuracy of seller's replies to inquiries, be it commercial inquiries, TA forms, or additional inquiries, and to identify whether or not the property is as identified in the contract. So back to this issue about boundary sensitivity. Client inspection involves actual notice of what they see, constructive notice of what they would see had a reasonable inspection been undertaken, and imputed notice. If an agent or anyone on behalf of the buyer client inspects on the client's behalf, the buyer is bound by anything that that party has had revealed to them. So we should be telling the client about the fact they're bound by anything that a reasonable inspection would reveal. And it flows from that, we should be telling the client what a reasonable inspection is. And it's also, I think, important that we identify from the client who's inspected the property on the client's behalf. And again, the client should be put on notice that they should be asking who has inspected whether anything unusual was identified or anything should have been disclosed to them. So again, if you've got a builder having a look at a flat roof and going in on his or her own to have a look at the property, then the buyer client should be asked to check with the builder whether there was anything wrong with regard to the flat roof and whether the builder was aware of anything that the buyer should be aware of other than the roof during that inspection. Clients should inspect before exchange. Where properties are empty, where properties are prone to vandalism or damage, they should be inspected at exchange. And clients should be inspecting before completion and at completion for disclosure of interest purposes. Surveys and valuations, great tip. Those of you that haven't heard my presentations before, the RICS has a consumer guide to surveys and valuations, providing great information to clients about the choices and benefits of survey and valuation. We should be ensuring, if a surveyor is instructed, that we see the survey or valuation. And it's also important that if we have information pertinent to value or surveying issues, that the surveyor is provided that. So, leasehold property, we've got 3 years service charge accounts in the contract bundle. Buyer client is instructing a surveyor to inspect. I would want the surveyor to see the 3 years service charge accounts and perhaps the lease to see if there are any issues that that documentation generates, courtesy of the surveyor's inspection. Duty to explain, be careful about giving advice. It's not enough to give me as a client a copy of a document. There should be an explanation sitting behind the document. You should be explaining to me risk, explaining to me how wording is interpreted, explaining that there are choices relating to interpretation. And you should be ensuring that where I am consenting to a course of action, I am doing so on the basis of having been properly and fully informed. Reporting on title, in the notes I've given you some detail there, but I think you should be connecting the report on title to client objective, and we should be making sure that we're communicating it to a client in a manner that means the client has the best opportunity to read and understand it. I would litter communication, be it a report on title, email, telephone call, etc., with the following. I'm assuming you've understood what we've said or what I've written to you. I'm assuming, if it's a written communication, that you've read everything that I've sent to you. If you haven't, or if you're not sure about anything, please let me know. I think we've got to be careful about making sure communication is effective. And I go back to that point that I made a little earlier. Conveyancing is, to an extent, a treadmill, a procedural thing. But as conveyancers, that's only part of the job. I think the most difficult bit, and again, professional indemnity insurers are telling me that it would appear to be becoming more and more difficult, is how and what we're reporting to our clients. So I do think we have to be careful in that regard. I've given you notes about electronic signatures. I don't have time to discuss that because I'm conscious of time. All I would say is watch out for the Mercury signing protocol, for signing incomplete documents and the risk of fraud, making sure that if you're a buyer, you take the lead with regard to the use of electronic signatures and make sure you've got systems and processes in place and a paper trail to confirm systems that you're using for electronic signature and client verification. On that happy note, I'm going to finish. And Stephen, say thank you very much indeed for looking after the IT side of things, and thank everyone indeed for attending today. And now it's question time, my favorite bit of the session. Stephen, are there any questions?
Yeah, thanks very much, Ian. Yeah, we have had a few questions in, which I will come to in a moment. As a reminder, if you do want to submit a question, you can do so just using the text box in your control panel. Just before we go to the questions, we just wanted to run a quick poll. It's regards to opening up and office use. So what we want to know is, with July the 19th fast approaching, what are your plans for returning to the office? So I'll just launch that poll now. You have 4 options there. We'll be returning to the office full-time over the summer. We plan to mostly be office-based with some home working. We're required to be office-based with a fixed number of days. We will be full-time home working for the foreseeable future. So I'll just leave people to answer that for a second. Ian, we've had a number of people actually. The question pane went mental when you were talking about the co-ownership questionnaire. We've had a number of people ask if we can share that co-ownership questionnaire.
Yeah, what I'll do, Stephen, I'll send you a copy of it, and gladly, yeah, not a problem.
Fantastic. Just coming on to some questions here, I'll just leave the poll there for a second. On the co-ownership questionnaire, we had a question from Mark. He says, I send out the questionnaire to which you've referred. Following its return, I send the client's details of the differing ways holding a property jointly and advise it sounds as though you wish to hold it as joint tenant stroke, tenants in common, equal stroke, tenants in common, unequal, but please signify on the attached form. Is it dangerous to say that it sounds like you wish to hold as a joint tenant in common or tenants in common?
Well, I would be saying that the way I would do it is change it slightly to say my advice is, given what you've said, my advice is that this is the way, but I'm dependent on your instruction. I think that's how I do it. So I would change the sort of emphasis a little bit, Stephen, yeah? If Mark understands that. Because at the end of the day, what we've got to do is we've got to say to the client, look, these are the choices. This is what I advise, but at the end of the day, it's down to you.
Yeah. Okay, that makes sense. Yeah, thanks, Mark, for that question. There are a couple of.
So I'm not saying, sorry, Steve. I'm not saying Mark's wrong. I'm just saying that from an emphasis perspective, I would change it slightly.
Okay, no, perfect. Thank you.
Thank you.
Mark, it's not a direct follow-on from that, but it came in just shortly after. So Mark says, are we not bamboozling the client from the outset by calling it a report on title? And he suggests that he would cause his a purchase report. So I think a language there.
That's a good idea. Yeah, good idea. Yeah, because in essence, we're not just dealing with title. I would have no objection to that, and I think it's a sensible thing to do. Anything that can demystify the process, I think, is a great thing. So anything like that, Stephen, I think is a good point. Yeah.
Fantastic. Thank you. Megan has asked a question about indemnity insurance. So Robert, I'm not sure if you would like to comment on this one. She says, Robert, could you share an explanation of what title insurance does? Obviously a rather broad question, but perhaps we could put something together there.
Yes, certainly. I mean, I don't know if she's talking about the notes I've mentioned that we've done for clients in the past. I can certainly send those to her. The reason why it's to my mind at the moment is we're just currently rewriting them. So happy to send a copy of those to her and to anyone else who wants them.
Perfect. Thank you. Kamudu, apologies if I've pronounced that incorrectly, but he asked, when you are requesting records of planning permissions, what type of documents should I look for?
Could you just repeat that? Sorry, Stephen. Thank you.
Yeah, of course. Sorry. And yeah, when you are requesting records of planning permissions, what type of documents should I look for?
You'd want permission and any conditions. So copy planning permission, copy of any planning conditions relating to it, that would be sufficient. But again, you just got to be careful, right? If it's a listed building, or if there's a detailed planning permission and your client has intentions with regard to development or redevelopment, then it may be that you're saying the client has got this documentation, but really, given your objective, you should be thinking about instructing a planning consultant to give you advice.
Perfect, thank you, and thank you for that question. Lakshmi asks, she said, thank you. It's fairly common that unregistered title deeds and required other documents not to be available to determine the legal boundary. Do we report the same, or should we suggest a land survey to be done?
Right, great question. Yeah, I would always, again, set realistic expectation. The only way to identify a legal boundary is to have evidence of what was intended when the boundary was created. I've made an investigation. There aren't any deeds or documents that are going to assist me with regard to that. These are your choices. Okay. One, you just buy as is with the risk that we don't know where the legal boundary is. Okay. Now, again, the advice as to whether you proceed or not hinges on client objective. Two, the idea of some form of survey. But again, I've just been in communication with the chartered land surveyor at the moment. who basically is trying to produce a survey report relating to a boundary. And in essence, he's sort of asking me questions all the time. And I'm saying, well, look, you know, I can't provide you with any information that's going to assist you with regard to the plan that you're producing. Quite an interesting thing, actually. It's one of these sort of sites that's been bought and split up into about 50 or 60 little portions and sold as sort of as an investment. And the guy that's bought this little portion of this potential development site is saying, I don't know what I've bought. So he's instructed the Chartered Land Surveyor to produce a plan to try and identify it. And the Chartered Land Surveyor is at me probably 2 or 3 times a week in the last couple of weeks saying, what do I do? And in essence, what I'm saying is, you've got a problem. A, because the plots adjoining the plot that's being purchased aren't registered. The plot hasn't been pegged or staked out, and therefore difficult, if not impossible, to advise a client what they bought. What I would always say in a situation such as that, if you're buying a plot, have the plot staked out. I'm just dealing with a matter at the moment where the argument is, where is the legal boundary, given that the boundary is a staked point and the stake itself is, was it 4 centimeters in width? Is the boundary at the northern side of the northern face of the stake or the southern face of the stake? Because that has a 4 centimeter consequence with regard to the size of plot. Just gets ridiculous. But I think what you've got to do is set realistic client expectation, give clients choices as to what can be done. But again, you know, the idea that a survey from a Chartered Land Surveyor or a report is going to give me an accurate fix, I think is a dangerous thing to do. The best thing to do, agreement with neighbour, determined boundary application, formal boundary agreement. That's your fix.
Perfect. Yeah, that makes sense. And thank you.
If I can just butt in there, Stephen, and in obviously where there are missing title deeds, you can look to get a missing title deeds policy from an insurer for missing information like that. So that may be something to give you a bit more comfort.
Yes, it's a good point. Good point, Robert.
Absolutely. Thanks, Robert. We just have one more question, then I will share the results from the survey we just ran there, the poll. Sorry. So Brian asks, an ancient unregistered conveyance plan is unlikely to be LRPG 40 compliant. You can't alter it. So what should you do?
You would technically ask the seller to produce a plan that is Practice Guide 40 compliant. And the seller, if we're using the conditions of sale, 5th edition or commercial condition, will be obliged to produce such a plan. But that would be an expensive exercise. Good question from Brian, actually. Would be an expensive exercise, but it's something that needs consideration at the start of the transaction. Often I see that issue arising during the registration process. And in those circumstances, it can be difficult getting a seller excited about getting things sorted out. So far better to get on with it right at the beginning of the transaction. Hey, there's an issue here. How are we going to resolve it?
Yeah, that makes sense. Thank you. Thanks, Ian. Thanks, Brian, for that question. So I think that's all the questions there. So just before we finish up, I'll just share the results of the poll we just ran there. And I think personally very, very interesting. The large majority saying that they will be returning full-time or have already returned full-time over the summer months, or will be mostly office-based. Just a small percentage there saying that there's a requirement to be office-based for a fixed number of days or full-time working for the foreseeable future. Robert, I don't know if you have any thoughts there, seeing those answers.
I'm actually surprised by the number returning full-time, but I suppose one of the issues you have with a conveyancing team is that exactly what Ian was talking about at the start. There is such a benefit from being in the same space so that you can bounce ideas off and help people. That's probably one of the motivating factors behind that.
Absolutely, yeah. I think we have a similar thing, really, Robert, with that we're discussing. It's the sort of the more junior members of our staff and their development. I think that's a big aspect that needs to be considered. Ian, I have to ask, so I take it your plan really is to be remote based as much as possible with IQ.
It's really interesting. I'm getting a lot of demand now for face-to-face training. I did my first face-to-face event since lockdown in June down in Bournemouth. But I'm getting lots of people saying, can we do it? Or hybrid, which is quite interesting. So we're doing a conference and I'm attending. Other speakers are doing some virtual training, and that's quite interesting. But from my own perspective, I'm looking at offices at the moment. My team is saying they would prefer to work from home, but I'm very conscious of the fact that you know, at some point for personal development, etc., it's nice to have staff together in an office environment. But as I say, the only thing that worries me at the moment is I'm just not sure, you know, when we get this sort of freeing from lockdown, just what happens with regard to COVID, and a little bit jumpy that we get back to square one again at some stage. So my plan is to do nothing until September, see how things are in September, and then probably think about an office and probably start pushing face-to-face. But I'd have to say, virtual training, this sort of thing, is here to stay. I mean, why wouldn't it? When you think about it, you know, if this was a face-to-face event, that would involve me traveling down to London, a lot of delegates traveling to London. I remember the last face-to-face thing I did pre-lockdown in London, there was a delegate who'd come from Truro and had come up the day before, was staying in London that night, listening to me droning on about something during the day, staying in London again that night and getting the train back the next day. And you think that's so inefficient. You know, virtual training must stay where it's got to be, because it's such a great vehicle for doing the sort of thing that we've been doing.
Absolutely. Yeah. No, thank you, Ian. Right, I think we will wrap up there. Thank you. I appreciate we are at nearly 12:15, so thank you to everyone for staying on and attending today's webinar. As I mentioned in the intro, we have included links in the chat section to our YouTube channel and our LinkedIn page, and Ian Quayle's LinkedIn page as well. Please do give us a like or subscribe if you do use these platforms. If you have any other questions, please do contact Ian or myself. Once you leave the webinar today, you will receive an automated message from GoToWebinar. If you respond to this email, the replies will come directly to me, and I can send any questions or feedback on to Ian and or Robert. You will also receive a separate email from Robert in the next couple of days, which will contain the slides and notes to today's session. And I'm pleased to say we will be back on the 4th of August for another one-off webinar looking at leasehold law, an update for 2021, details of which will follow shortly in the next week or two. That just leaves me to say, on behalf of Stewart, Title and Ian Quayle, thank you so much for joining us today, and have a great rest of your day. Thanks everyone, goodbye.